from my experience. And that is a fundamental right and freedom that has been established by the Constitution of Kenya, 2010. Okay. We also have the rights of employers here, because the Constitution doesn't just provide for rights of the employees. It also provides for the rights of the employer, whereby the employers have a right to form and join employment organizations. In this area, we are looking at I have seen many people in the hotel industry. They have formed employer organizations, and the same have been registered so that they can govern and look at the important factors that need to be considered in that industry. And many other industries also have joined and formed organizations to assist them in putting a playing field for all the employees in those sectors of trade. Employers also have the right to participate in activities and programs of an employer's organization. They enjoy the same rights that has been conferred to employees to form and join the unions. They can also participate in the programs. And this, I think we always see it in CRSs, where they are giving back to the community. Most of them are always organized by the employer organizations. We also have the rights. Every trade union and every employer organization has the right to determine its own administration, programs, activities, and to organize and to form and join federations. We've had federations of Kenya Federation of Employers, right? Whereby they can join and they can form these organizations, and they have the right to choose their own officials. Nobody will come and dictate upon them the officials that they should have in their organizations. All this is based on the Constitution of 2010. And finally, we have every trade union, employer organization, and employer has the right to engage in collective bargaining. Now, the employers have this right to engage in collective bargaining. We also have the employees who have also been given this right. It's on both sides, but many times people tend to think that it is only the employees that have been catered for when it comes to this issue of collective bargaining agreements. In this program, we'll be referring to them as CBAs, so that I do not twist my tongue when trying to pronounce the whole word. But yes, we are all familiar with CBAs, and the employers also have the right to engage in collective bargaining together with their employees. So at this moment, we are going to delve into the Employment Act and give a little bit more detail of what it provides for. I know this is an area that most of you are interested in, because most of you are working in the HR department. I assume all of you actually are working in the HR department, and these are the things that every HR should have at the tips of their fingers, so that in case of any dispute, you know, or even before a dispute comes into play, you already know what to expect. We will start with the types of contracts. We have two types of contract. We have the contract for service and contract of service. These almost have the same amount of letters, number of letters, but we have one more letter, for and of. Anyway, I'll be explaining for you the difference in just a minute. A contract for service is a contract required when one wants to engage the services of a third party as an independent contractor for a specific project or a short-lived purpose. This is different from a contract of service, which is used in labor law to attribute rights and responsibilities between parties to a bargain. Now, the difference between the contract for service and the contract of service is the contract for service does not confer the rights of an employee. The person who has been contracted under a contract for service is not an employee of the organization that contracts him to do a service. I'll give an example. You want to construct a complex, business complex, or a hotel. You'll probably contract, I'm sorry to use the word twice, you will hire a contractor. They always refer to them as contractors, but in this place, I'll be saying building expert. So somebody who is supposed to do your building will sign a contract with you, or somebody says, I am breaking. Let me try to see if my Wi-Fi is, let me just try to fix that. Am I still breaking? Okay, thank you so much. Thank you so much for the feedback, Joy and Rosemary, sorry. Thank you so much. Thank you for that. So the contract for service, when you hire an engineer or a private contractor, that is why we refer to them as private contractors, to do for you a work for specific time or for a specific purpose, say to construct for you a hotel, you will not be conferring on them the rights of an employee as you would have it in a normal employer-employee relationship. Whereas if you contract somebody who is paid even on a daily basis or a monthly basis for a period of time, under which you are supposed to supervise them, you are now conferring to them the rights of an employee as enshrined in the Employment Act. We'll move on swiftly to, the previous slide is about the two types of contracts. Now, we are going to delve into the different categories that we'll be dealing with when it comes to contract of service. This is the area where HR is interested, contracts of service. We have got the permanent contracts, we've got fixed term contracts and casual contracts. If I'm going fast, kindly tell me to slow down. So on permanent contracts of employment apply to employees who work regular hours and are paid a salary or hourly rate. The contracts are ongoing until terminated by either the employer or the employee and may be for full or part-time work. Now, these contracts are common in government, though recently they have changed some aspects. I've seen some positions in government that now have a tenure, especially when we had the introduction of the devolved governments. We find people in counties are given contracts. Most of them are not employed on a permanent basis. Here, we are mostly looking at maybe the contracts where we have the government workers in government institutions that are not based on a county level. This is where it is common to find these types of contracts. We have the fixed term contracts, which give a set end date, for example, 6 months or 1 year. Now, these are the ones that are common these days. And these are also mostly in the private sector, because we always see a number of private sector organizations giving contracts for 2 years, 3 years, and then the county governments we see mostly 5 years, and that's mostly based on politics, because they believe that after the 5 years there'll probably be new people coming in and they would not maybe want to retain the former set of workers. I don't know why that is the case, but it happens a lot. We also even have those that are fixed for 6 months, and these are common in the hotel industry, whereby we have the low season and the high season. And in the high season, they employ most staff after maybe 3 or 4 months. Those staff contracts come to an end and they go home and maybe wait for another contract period. This is also common for non-government, non-profit organizations, the NGO, non-government organizations that are non-profit, We also have them having a lot of contracts on a fixed term basis, and those can also be renewed at the pleasure of either the employer or the employee. Finally, we've got the casual contracts. Now, the casual contracts specifies the minimum number of hours that you are expected to work each week, with the exceptions being that working patterns and hours offered above the minimum are likely to fluctuate. This is common in the production sector of this country, where you have the industries. They always have people on casual employment, and this, how they do it is that they give you a casual contract that mostly runs for a period less than 3 months, and you're expected to work. They give you about 8 hours, and any hours that are worked over the 8 hours are normally paid an overtime. Excuse me. Now, we have this problem here that faces many HR practitioners in this country. There is normally a very big debate on when a casual contract can be converted into an employment contract. This used to happen before, I think in the year 2010, when they had just introduced the Employment and Labor Relations Act. We used to see in the newspapers and everywhere in practice, we used to see that many people come to court and say, I've worked for this company for 6 months and I've been a casual laborer. For that reason, I automatically am entitled to the rights that are conferred on an employee. So when does a casual contract get converted into an employment contract? If a casual worker, I'm hesitating to call them employees because at this time they are not employees. If a casual worker works for a period or a number of continuous working days, which amounts in the aggregate to the equivalent of not less than 1 month. Okay, how is this? If someone works continuously, like from 1st to 31st of a month without the 1 day rest that is provided by the Act, they will become an employee by default. And you will have to go through a lot if you have this case, because they may sue you and say you've not paid for them NHIF and NSSF as an employee, and then you'll be held liable for that. A casual laborer who performs work which cannot be reasonably expected to be completed within a period or number of working days amounting in an aggregate to an equivalent of 3 months. Now, if you give somebody work on a daily basis and you're paying them per day, but it's impossible for them to complete that work within 3 months, then you may face that big problem of having them converted into employees. So what do you do in case you want to avoid this kind of situation? One, make sure that you do a proper casual workers contract. Many firms don't actually do that. What they do is that they just get a book and every day people report to work and then they sign and that's it. You know, they sign the document, I mean the book, and they say I'm present today, and then at the end of the week they go and collect their money, and it continues like that. Somebody will actually come and claim that you have employed them and they've been working for you for those days, and sometimes that book may not really serve you in court, you know. Another thing that you can do to avoid this is always send the workers on holiday. Send those workers on holiday. Because when they go on holiday, by holiday I mean in a period of a month, at least give them 4 days off, okay? Give them a day off every week, then the aggregate will not amount to 1 month. Or in the period of 3 months, After the 3-month period, send them on holiday and then contract them maybe after another 2 weeks. That means it is not a continuous kind of engagement. That will save you a lot. So, oh, sorry, I think my slide got mixed up here. I'm sorry for that. I'm sorry. I'm really sorry for that. I had already started on the Employment Act, so I will just skip these parts because we are already into the discussion. I'll rearrange the slide before before posting it into your inbox. We discussed contracts already, and we'll now go to the legal, oh my goodness, sorry. The legal rights and obligations of employees. After we've established the employee-employer relationships, when it comes to contracts, we now have the rights that are conferred to the employer and the employee, and this is provided for in the Employment Act of 2007. In Part 4, the Act provides for basic minimum conditions of employment. Now, these rights are conferred on employees who are under, as we said, contract of service, right? Section 26 of the Employment Act provides for a CBA, okay? In case you have a CBA or a contract with more favorable terms than what we are about to discuss in this section, then those terms will prevail against the terms that we are going to discuss here. Basically, the Employment Act has just laid down the bare minimum that is expected for the employee or employer to enjoy. And anything above that will be held at a priority as opposed to what is provided for in the Act. I don't know, my camera has changed. I don't know why it has changed, or is it me who has changed? I'm sorry for that. Section 27 of the Act provides that every worker is entitled to 1 day of rest in every period of 7 days. That is a week, right? That is a week. So in 1 week, everyone is entitled to 1 day rest. Most of these companies give Sunday as the rest day. It is common in Africa. In other countries that are maybe based on another system of governance, for example, in the Asian countries and in mostly Arab countries, we find that their rest day is on Friday. So as long as it is 1 day in a week, you can choose which day to give to your workers to rest. We also, I beg your pardon, there's a chart here I'm trying to see. Okay, sorry. I was trying to check, maybe somebody was not hearing me. Section 28 of the Act also provides that every employee is entitled to 21 days leave with full pay after 12 months of consecutive service. Okay? This is the one we commonly refer to as annual leave. I know some people don't give annual leave. Are you a culprit of this? If you do not give annual leave, you are expected to pay the worker that does not go on annual leave a salary in lieu of the leave, because it is their right. And you can do this by distributing the leave days in a sensible manner. It doesn't have to be 1 month in a row. You can have somebody take a week off. You can have somebody take 2 weeks off, or the whole month at a go. I don't know if your organization has got leave forms, because this will be very important in case of a dispute. Most times when you go to court, you find people telling the court that they never went on leave for 20 years when they were serving in a certain organization. And at that moment, the company has changed management so many times and documents have been lost, especially leave forms, and they are unable to prove that this person actually went on leave, what will happen? The organization will pay for all the time the person claims not to have gone on leave. Unfortunately, the burden of proof shifts from the employee proving that they never went on leave to the employer, because now in this instance, the employer will have to prove to the court that they actually gave leave and this person proceeded on leave. That is why sometimes when people don't take leave, they are given a forced leave because it is their right. It's just like in the prisons, we always see people have a right to eat and they are forced to eat, and they cannot say they cannot eat and they do not want to eat. So if your employee doesn't want to go on leave and you do not have extra money to pay them, or you actually do not need them to be on the premises, please send them on forced leave. It will save you a lot, a lot of money, because one day the employee will leave the organization and then you will pay them for not taking leave. And in case they don't take leave and you pay them in lieu of leave, make sure that you keep these documents for at least a period of 12 years, because that is the requirement. But if somebody is in employment, that means you have to keep their documents until they leave the employment. If they work for you for 25 years, you're required to have all their documents from the first day they stepped into your workplace. Section 29 provides that every female employee is entitled to 3 months maternity leave with full pay. And the same can be extended with the consent of the employer. Why is this? Because women, or the female gender, has been given that natural rights and obligation to bring life into the world. So when the female gives life to the world, they are expected to go on leave because the child needs time to be taken care of and needs time with their mother. Also, there is a provision for extension of the leave, because sometimes the females, they go through a problematic maybe maternity, or they go through a problematic birth where maybe they have had a C-section, then they've not completely recovered within the 3 months. The law has given this provision to cater for that aspect. And we also see the law providing that after expiry of the maternity leave, the employee has a right to return to the job she held immediately prior to the maternity leave, or to a reasonably suitable job on terms not less favorable. Sometimes we see organizations who make this mistake. Somebody is sent on maternity leave and they were probably head of a department. And then when they come back from maternity leave, they've been demoted. This is illegal and you could be sued for that. And guess what will happen in case you're sued? You will pay. You will pay for damages, and you will probably be asked to reinstate this person back to the position they were on before they proceeded on maternity leave. I think this is a very unfair practice, and it is common. In case you are doing it in your organization, please repent. Please repent before you are sued, okay? And change your policies. Robert, I see your question. We'll be tackling that question at the end of this presentation, because we will have a Q&A segment. So I'll be going through the chats again to see the questions. I've seen your question, or can I just tackle it here? Robert is asking, are employees on contracts entitled to maternity leave? Of course they are. If a contract is more than 12 months, they are entitled to maternity leave. They are entitled because it's a term contract. So yes, it is their right to have maternity leave. It's good I've answered it right away. It is their right because they are on contract. So they are entitled to maternity leave. And if you do not give them maternity leave, then you might be sued. Those are things to avoid. So just give the person the maternity leave. But it also makes sense because you do not expect a woman who just gave birth to come and work. It's impossible because they will not even pay attention to your work. They will always be thinking of their child. Productivity is at a very minimum level when it comes to women who are just fresh from maternity. That one I can tell you from experience. Because even when you're at home in the 3 months, you're literally just thinking about the child. You could even forget to eat. It's funny, but it is life. So yeah, to improve the productivity of your own organization, please give those people maternity leave. Somebody else is asking, is it okay for an employer to pay employees leave instead of letting them go on leave? Yes, that is an option. That is an option. If you do not want to send them on leave, you can simply pay them in lieu of leave. Now, this definitely means that at the end of the year, you'll be paying them double the salary for a month. But remember, this should not be considered as a bonus. Payment in lieu of leave is not bonus. Many people just hide it and they say, oh, I've given you a payment in lieu of leave and it also works as a bonus. No, it is a right. So if you're giving out bonuses and somebody did not take a leave, you will have to pay them extra and you will also have to give them their bonus. You cannot deny them a bonus because they did not go on leave. Okay, somebody else is asking, Esther is asking, what happens if the contract expires when the employee is on maternity leave? If the contract expires and she's on maternity leave, you simply have to pay them for that month, and then the contract expires and you can choose to renew it or not to renew it. Now, that is definitely up to the employer to renew the contract or not, because time still runs when the person is on leave. They are considered to have worked whether they were on leave, when they were on leave, whether they worked or not. So they are considered to have worked. So definitely the contract will expire and you move on. Robert again asks, what if the contract is for 1 year? Will the employee be entitled to maternity leave? Yes, they are entitled to maternity leave. As long as, that is why we started by discussing the contract of service. The contract of service, even if it's for 6 months, it entitles that person to all the benefits that we are discussing under this segment of the discussion, okay? More questions. Okay, Joy is saying, kindly, can people switch off their cameras? I have seen someone dressing up. Oh my gosh. Please switch off your camera if you're not presenting. Sorry about that, Joy. Sorry about that. Doreen Onyango, kindly switch off your camera in case you're not presenting for decorum, because we do not, this meeting is being recorded. And if you have, as our leader always said, do not be an embarrassment to the profession. So kindly switch off your camera so that we do not have those interruptions. Doreen Onyango is saying, what if someone is on 6 months fixed and non-renewable contract, which expires on September and she's due in August? Are you still obliged to pay her full maternity leave? No, in this case, you do not have to pay full maternity leave because their contract was expiring anyway. So you do not have to pay them full maternity leave. This name is disappearing. Mar says, do you pay the employee leave equivalent to 1 month's salary? Of course, yes. You pay them equivalent to 1 month's salary, okay? My camera changed. I'm not comfortable with it. I want to be in the middle, but it has changed its position. I don't get it. So I'll move on swiftly to the next provision. We are still continuing with leave. The employee proceeding on maternity leave must give at least 7 days notice or a shorter period as may be reasonable. Now, why is the act providing for 7 days notice when you're proceeding on maternity leave? This is so that the organization can prepare itself for your absence and probably put somebody to hold your position until you are back. This helps the organization to reorganize their structure to provide for your absence. Now, it also says you can give shorter period of notice as may be reasonable. Sometimes we have people working until the last day of their leave. Like they are just at work and then they go into labor. We've had situations like that. And this is because they are trying so hard to have the complete 90 days or 3 months with their little baby. So they work until the end. So notice here, you'll get notice on that same day. But anyway, it is reasonable like that. So the Act clearly provides that no female shall forfeit their annual leave on account of taking maternity leave. We always see organizations penalizing women and telling them they can't go on annual leave because they had maternity leave. This is wrong. The Act clearly states that the female will not forfeit. Remember, they are talking about females. They're talking about females here. You will not forfeit your annual leave. You will be entitled to your maternity leave and your annual leave. So as HR practitioners, if somebody takes their maternity leave, it doesn't mean they cannot take the annual leave. And most times in government, we see people taking their maternity leave and then they add their annual leave on top of that. So they have like 4 months of leave. Some employers frown to that, but it is their right and there's nothing you can do about it. Or you'll have to pay them. A male employee is entitled to 2 weeks paternity leave with full pay. I don't know whether men are taking paternity leave these days. Most of them shy away from taking paternity leave. And some of them don't really shy away, but they don't want to go home and hear the child crying. They don't want to do that. They just want to stay in the office and say, hey, kale kamtoto naka kanalia sana. But the mother needs your help. So please if you have a male employee and you hear that their wife has given birth, send them on leave for 2 weeks. But anyway, you will pay them for the 2 weeks. I see Nixon is laughing. Nixon, do you take leave? Or you just hide in the office? Anyway, that is on a light note. You don't need to answer that. So yes, men have also been catered for when it comes to leave, paternity leave. And this is very good, and especially for the parents to both bond with the child. We have a new aspect of the law, and this one is catering for adoption. These days, we have new developments in court where many people are opting to adopt children as opposed to giving birth. And some of them actually just adopt, even when they've given birth, they adopt the children so that they can give birth to the society. So we have an amendment to Section 29, and we have an A, which has been introduced into the Act, whereby an employee is entitled to 1 month pre-adoptive leave from the date of placement of the child in the care pursuant to a court order. So how does this happen? When parents have gone to an adoption agency and they've gone through the process and a child is about to be placed in their care, they give a 14 days notice to the employer that they will be having a child they are adopting and that the child is coming to stay with them. And then they are entitled to 1 month. Each parent is entitled to 1 month after they have served the employer with an adoption order. Make sure you get the order. Just don't listen and say, oh, I'm adopting a child, and then you have no court order. There's somebody responding here. Somebody asked, what if an employee is on probation? Do we count the days while on maternity leave as probation, or we extend? From my experience, you will have to extend the probation. From my experience, you will have to extend the probation. I've seen a case in court before where somebody was terminated. The employment was terminated based on an appraisal that was done immediately after her maternity leave, and she was paid by the organization because the court found that it was the the assessment that was done by the employer was not fair because she was assessed even during the period she was on maternity leave. So you will have to extend the probation. How many leaves can one carry forward in one leave year? And how long can they continue keeping the many days due to the capacity issues and organization does not have staff to sit in for the employees while on leave? A staff who has 100 days accrued leave days, can you forfeit all the days to zero? No, you cannot forfeit their days. You have to pay them. If you do not have enough capacity to hold positions and people have to accrue leave days, you have to pay them for their leave days. You cannot forfeit their leave. So if you calculate their leave days and you find that they are 100, those are probably 3 years of not taking leave, 3 or more years, just pay them. Because on the day that you terminate their services, that is when you will know that it is not good for them to carry on their leave days. And many people don't actually like to take leave. Send them on first leave if they don't like to take leave, because it will only save your organization money. If you not send them on leave, the organization will pay. Simon says in Tanzania, it's 4 days only. Is that for paternity leave? It used to be 4 days in Kenya as well, but it changed. Esther says depends on the company policy. Remember, it doesn't matter what the company policy says, as long as it is against the Employment Act, then you will not really achieve much. Okay, now, what I'll do, let us just go through the slides when then we finish and come back to the questions, because we may end up staying on this leave issue for 4 hours, and yet our course is for only 3 hours, okay? So I'll go back to the slides and then I'll come back to the questions at the end of the slides, okay? I'll try to go through them faster so that we have at least 30 minutes of questions, okay? Section 30 of the Employment Act states that every employee is entitled 7 days sick leave with full pay after 2 months of service. This one is clear. After 2 months of service, the employee is entitled to 7 days sick leave in a year, okay? In a year, but the entitlement starts after 2 months of service. Section 30 goes on to say, after the first 7 days, they are entitled to 7 days more with half pay within a year, okay? After that, it will now depend on the company policy, because some companies actually extend the leave, and in times when somebody has become sick for a very long time, company policies will now come into play. Because remember, the Employment Act only gives the bare minimum. Reasonable notice is required for somebody to proceed on sick leave. Many a times when you go to work and then in the morning you just receive an SMS, or in fact, not in the morning, just at 10, like somebody is supposed to report to work at 8, and then at 10, they send a message saying, I'm sorry, I couldn't make it, I am sick. How do you treat that? That will entirely depend on your company policy, but the Act provides that they have to give you notice in reasonable time. But even from experience, sometimes we have like judicial officers, they just send a notice saying the judicial officer is indisposed and then will not be able to proceed with a court case. Is that considered to be sufficient notice, reasonable notice? Well, they say sickness is not normally foreseen, and that is why reasonable notice can even be instant, okay? Full pay means basic pay and excludes deduction. When it comes to sick pay, when somebody is sick and they go on leave, their full pay, it means basic pay and it excludes deductions. We'll be tackling deductions later in this presentation. We'll be just throwing a little bit of light on the statutory deductions and non-statutory deductions. Section 30 provides that, no, that we have done already. Section 31 provides that employers shall at all times at his own expense, provide reasonable housing accommodation for his employees, or shall pay the employees such sufficient amounts as rent. You know, this was very easy long time ago because there are very few people who are employed. These days, you find an organization has 1,000 employees. 1,000 employees, it may not be possible to house all of them. Those days, they used to reserve housing for the managers and the big people, the HR managers, the general managers. I know many of you here have housing. You can share with me. Anyway, that is on a light note. But yes, the Act provides that you have an obligation to provide housing or give them housing allowance. This is the one we see on the payslip as housing allowance. But sometimes this is provided for as a consolidated salary. In most private organizations that are not so big, I don't know why my camera keeps changing. I don't know what I have to do to it. Okay, I think this position is much better. So we have most organizations provide for a consolidated salary where they say your salary is consolidated and it shall be 100,000. That is before deductions. That is an easier way of dealing with this issue of housing and housing allowance. Section 32 provides that you have to give your employees water. This is very important. Water, they say water is life. I don't know if that is still the position these days because many things now are life, apart from water. But anyway, the Act provides that you should give water to your employees. So make sure the water is clean. It doesn't just mean water for dirty water. No, proper drinking water. This is what they are referring to. Section 33 provides that you can provide food in cases where it has been expressly agreed to at the time of entering the contract. So when you're signing a contract, please, if you're giving food on a daily, include it in your contract that you're giving food. In case your company decides to be happy with the employees and then gives them food for a month, and then after 1 month there is no money, they can now not come and claim that we are entitled to food if it was not part of the contract. If it was part of the contract, then you have to give them that food endlessly. We have companies which provide lunch, break tea, evening tea, and that is a very, very good gesture, and it almost, sometimes it encourages people to work better. Section 34 provides that employers shall ensure provision of sufficient and proper medicine for his employee during illness and, if possible, medical attention during serious illness. Now, this is where we see most organizations have a nurse in the premises or a doctor who will deal with the injuries that happen in workplaces, maybe the first aid, and sometimes we have most times actually, we have the injury benefits that has been paid for, like an insurance for people who get injured at work. Remember, this medication is to be provided for accidents that happen at work. And this also forms the basis for work injury benefits and the claims that we always see pegged on injuries sustained at work. Now, the burden is upon the employer to know of the illness of the employee. Can you imagine? I don't know if this is fair. The burden is upon the employer to know of the illness of the employee, because it is considered that maybe they contracted this illness during their work time. The provision does not apply if the illness or injury was contracted during a period when the employee was absent from employment without lawful cause or excuse. Now, if somebody misses work and they get injured or they get knocked by a car, the employer is not obliged to pay for their medication. Also, their medication will not be paid for if the illness or injury is proved to be self-inflicted. There are some workers who just want to inflict injury on themselves and then claim that the employer is supposed to pay them. No, this is not the case, you are not obliged to pay this. And then now this last one is the cheat code. I'm giving you a cheat code here. The last one. That the employer will not or is not expected to pay for injuries of an employee if there is free treatment provided by the government. That is a cheat code for you guys, but don't quote me. But anyway, I'm just telling you for free that if somebody has been injured and there is a level 5 or level 4 hospital nearby and they are giving out free treatment for that particular injury, you are not obliged to pay in a private hospital where the employee can actually get treatment in a government institution that is offering the treatment for free. Many times you see maybe a work injury has occurred and somebody wants to go to the most expensive hospital because they have got the injury while at work. Well, you have the right to refuse if that injury can be treated at a government hospital for free. And also the treatment cost must be reasonable for the employer because it cannot be considered as a punishment to the employer because an employee was injured. So we are now moving on to, just wait a minute. We are moving to statutory benefits. Statutory benefits. We are continuing because we are looking at the illnesses. We now go to another aspect that has been changing. The statutory benefits has been changing with in fact, in May, on 1st of May, we had some few changes that were announced, though the same have not yet been gazetted, but they've been announced. What other statutory benefits does a worker have against the employer? They are entitled to pension or retirement benefits. This is mostly found in government organizations, government institutions, sorry, where the workers have a pension, and this is normally paid at the end or at the retirement of this worker, mostly in permanent kind of contracts. We have the National Hospital Insurance Fund deductions. This is a statutory benefit. Though it's a deduction, it is a statutory benefit to the employee because when they get sick or when their family gets sick, they can always go and use their NHIF card to have their medical bills paid. And these days we've got a great improvement in NHIF because they pay a higher threshold than what they used to pay in earlier years. We also have the National Social Security Fund, which is commonly referred to as NSSF. This always caters for retirement benefits for the private sector. The people in government, they get the pension and they can also contribute to NHIF, so they get two retirement benefits. Whereas in the private sector, we mostly have the NSSF, but I have seen many private sectors register their own private pension funds, especially in the hotel industry. Like they create a fund and then they contribute to the fund, and when somebody works for the organization until their retirement age, they actually get to enjoy pension for what they used to work for. Now, these statutory benefits are not payable when you're dealing with expatriates. Expatriates are people who normally just come mostly on a contract basis, and they actually do not pay most statutory deductions in Kenya because they are considered to come here for a specific purpose, and they even are considered not to spend their monies in Kenya. So we have the NHIF rates that are prevailing at the moment. There was a little bit of changes, and I've put them in this slide, 2 slides actually, for you to easily access them. They range from people earning from 0 up to above 1 million, okay? We also have the NHIF rates here. According to the NHIF At the moment, you are required to contribute 12% of the employee's basic salary. Now, 12% has been divided into two. The employee will contribute 6% and the employer will contribute 6%. So when you're taxing or when you are deducting the NHIF for your employee, you will only be deducting 6% of their basic salary, and then you will be getting 6% from your own pocket as the employer, and then putting it into that kitty of the NSSF, so that when they retire, they can have something to go home to. We are now entering the taxes. Why is it important for you to know the taxes as an HR manager? Many of you just leave this tax issue to the accountants. But when the cases come in court, the accountant will not be called to testify. It is the HR manager who will be called to testify in most cases. And in case somebody has a dispute saying they were deducted unlawfully or not properly, it is the HR manager who will most probably be called to say why they have been deducted in a wrong manner. So we'll talk briefly about payee, because this is a statutory deduction that emanates from the benefits or the salaries that the employee is expected to earn at the end of the month. So what is payee? Well, payee is actually pay as you earn, okay? Pay as you earn. And this is a method used to collect taxes from residents and non-resident individuals from profitable employment. Okay? What is profitable employment? The profit that you get from employment, and this includes wages, salary, leave pay, sick pay, fees, commissions, bonuses, gratuity, traveling, and other allowances. Now, these allowances are taxable by the Kenya Revenue Authority. Okay? And when is this payee payable? Payee is applicable for employees earning a monthly income of 24,000 Kenya shillings and must be remitted before every 9th day of the month. You're wondering why I'm tackling this aspect of the law. Well, it has a lot to do with the salary payment, because you are unable to pay salary if you do not know how much you're supposed to deduct from this salary. And sometimes an employee will come to you and ask you, why have you deducted this amount of money from me? And as an HR manager, you should be in a position to explain to them that payee is part of deductions. Many employees don't like to pay payee, by the way. They don't like. And they tell you, I just want to know what I'm taking home. I don't care what you're deducting from my salary, but I want to know that I'm taking home 50,000. I don't care about the deductions. But it's important for you as an HR manager to tell them, so that when you're drafting the contract, you know how to deal with this aspect, okay? Wait a minute. Now, we have non-cash benefits that are also subject to payee. This has been an area of so much discontentment, because people feel like, you're already taxing my basic salary. Why should you go ahead to tax the vehicles that I use? Why should you go ahead to tax the housing that you give me and the loan that you give me? This is provided for under the Income Tax Act. In as much as you are a HR manager, it is important for you to know that these non-cash benefits that are given to your employees are supposed to be taxed, so that you can save your company from paying fines to the KRA, okay? So I've listed the benefits, non-cash benefits that are taxable and attract payee. We have vehicles and car benefits. We have provision of housing. So when you're providing housing, this payee is supposed to be taxed. Uko mwisho. If you give a loan, at an interest rate that is lower than the market rate. For example, if the market rate is 14%, okay, and you've probably given a loan to your employee, which is maybe 6%, the excess is supposed to be taxed by KRA. Housing facilities such as water, electricity, telephone, security, and other expenses above 3,000 per month. This is also supposed to be subject to payee. That is why you see most times in government organizations, somebody has got so many allowance, leave allowance, they have got the hardship allowance, and then at the end of it all, they are taxed a very high amount of money, and you're wondering, is it only not supposed to tax basic salary? No, that is not the position. You are also supposed to tax all these allowances. Pension contribution paid by a tax-exempt employer to an unregistered plan of over 20,000 per month. Okay. Now, this comes into play when we are dealing with pensions. Unfortunately, pension contributions of an unregistered plan, that is, if it is not NSSF, and maybe you have your own plan for the employees, they will now be taxing you. Pension contribution paid by employers to a registered plan over 20,000 per month. So everything is getting taxed, and it's important to be conversant with these taxations, okay? Now we have also employee benefits that are not chargeable under payee. If you give these employee benefits to your employees, please do not tax them. We have the medical cover by the employer. Most times we have employers giving out medical cover to the employees. Please do not tax this aspect, okay? Because it is not tax, it does not attract payee. Pension contributions paid by a tax-exempt employer to an unregistered plan below 20,000 per month. Now that is the opposite of what we saw in the previous slide. All pension contributions below 20,000 per month are not taxable, okay? Amounts paid by the employer to reimburse or expenses done by the employee to the for the company. For example, if somebody has spent their money on transport and you are refunding them at the end of the month, and you have to include that in the pay slip, kindly do not tax that refund. Amounts paid by employers as gratuity or for the registered pension scheme. Okay, gratuity, we will be dealing with gratuity at the end of this discussion. We'll be dealing with that, but gratuity is also not subject to pay. Education fees paid through employee income that the employer has already taxed. Maybe somebody wants to pay for a master's degree and they want you to deduct the same from their basic pay every month. You do not have to tax the fees that are coming from the income that is already taxed. Meals offered by the employer below 4,000 per month. If you offer meals to the employee, you do not have to tax the same as long as the amount does not exceed 4,000. I don't know how practical this is in this economy, because even just one plate of food these days, a decent plate of food costs almost 1,000 shillings. And if you are providing food every day, definitely that's more than 20,000 in a month. I think they need to review this, because 4,000, in my opinion, is very low in this day and age. Then they also provide for nights out. They provide for nights out. So if you give nights out to your employees and then they are spending a minimum of 2,000 per day, then you do not have to tax them that benefits under payee. Now, non-Kenyan citizens are exempted from payee taxes in conditions where they are in Kenya to serve an employer solely and on passage between Kenya and places outside Kenya. For example, if somebody is going through Kenya, maybe they are Tanzanian and they are driving a lorry through Kenya, and then they get to receive a salary on transit, their salary is not to be subjected to payee. It doesn't matter whether they are in Kenya. Maybe they are here for a month and they are stuck for a month. They do not have to pay payee because they do not have a KRA PIN anyway. Now, we were talking about the statutory benefits that are required under the law. We are now going to talk about supplementary employee benefits. Employees actually have so many benefits, but most companies don't incorporate all this. But we are discussing it for the pleasure and the information of those that actually give these benefits. We have educational assistance. In government, many people are sent to do their masters and PhD, and the government is paying them or subsidizing for them their fees. We have mobile and internet allowance. We have life insurance. I don't know how many companies provide this for their employees. We have accidental insurance. This is very important. We have, we have a benefit of identity theft provision. If you have data of your employee, you are expected to provide for security for their data or identity not to be stolen. For example, if you're working in the tech industry, most times you have these problems to deal with identity theft. You have their NSSF numbers, you have the NHIF numbers, you have their KRA numbers. You have to protect this information because I once came across a problem whereby an employer, I think, had not kept the information of their employee properly, and somebody was using a KRA PIN that was not theirs to actually remit payee. And at the end of the day, the owner of the KRA PIN was now subjected to pay a lot of penalties. This was very wrong. So you have to provide for protection of the identity of your employees so that the identity cannot be stolen, okay? You also can provide for financial counseling, discounts on goods and services. We see mostly like in the telecom industries, they will be selling discounted telephones to their workers. Workplace wellness programs, well, this is provided for. Maybe you can give that as a benefit to your employees if you like, because some of them need mental health. You can take them on retreats. Sometimes we see this thing called team building. Team building is mostly to encourage workplace wellness. We can have some workplaces with a gym and spas and everything, and employees can actually enjoy that. We also have most workplaces which have pick up and drop off facilities for employees, whereby they pick the employees up every morning and or when need arises. Then dependent care assistance, maybe when the employees are advancing in age, you can provide for their dependents care. Employee meals that we discussed, you can give them meals if you like, even if it's not part of the contract. Then we have also dental insurances. Many companies actually give dental insurance to their employees. We also have bonus compensation, that one we had mentioned earlier, that payment in lieu of leave should not be considered to overtake a bonus compensation. So some companies actually give bonuses, and mostly in the hotel industry where they call it service charge. Yeah, in the hotel industry, they call it service charge, where they give you a bonus in case maybe their sales exceed a particular amount of money. They always give that out. These are supplementary. You can give them or you cannot give them. The law does not impose them on you as an employer. So we are on minimum wage. We have now discussed the fact that everybody is entitled to salary if they are under a contract of employment. Minimum wage, I have actually just extracted the schedule because we were expecting an increment on 1st of May. but it didn't happen. Mostly on 1st of May, Labor Day, we always have the reviews of the bare minimum when it comes to salary, but this year we did not have that. So what we have on this minimum wage schedule is what has been applicable from last year, and it is continuing to be enforced. This will be available for you. And as you can see in column number 2, they have taken care of Nairobi, Mombasa, Kisumu, Nakuru. I think these in Kenya are expected to be places where the cost of living is relatively high compared to other areas of the country, and that is because they are considered to be cities. Nakuru, I think, was recently added. And then we have all former municipalities and town councils of Mavoko, Ruiru, Limuru. Okay? These, I don't know why they chose these 3. Mavoko, Ruiru, and Limuru. All former municipalities and town councils. Wow. And then all the other areas, they have a lower rate. I don't know why, but I believe the board has a reason to that. So make sure you take note of this minimum wage. I will not delve so much into them because they are in the slides, and we have so many HR practitioners that are practicing in different areas, and they have different services that are being offered, okay? So you can take time to go through them when you finish this presentation. So we are now going to the aspect of payment of salary. This is catered for under Part 4 of the Employment and Labor Relations, and of the Employment Act. And we have modes of payment for salary. Salary can be paid by check or in cash or by bank transfer to the employee, sorry, or it can be paid to an authorized person. We'll be talking about this authorized person in a while. Where can the salary be paid? In case it is in cash or by check, you have to pay the worker on a working day. A working day in most institutions includes a Saturday, like today. And in most institutions, it does not include Sunday, though there are some institutions where it includes Sunday. So make sure you pay your employee's salary on a working day. Also, you have to pay the salary during working hours. That's what the Act provides. Many times somebody, maybe who are working for private people, they just are called at midnight and say, I've sent you your salary at midnight. Or they just send the salary in M-Pesa and then just send a messenger. It's encouraged for the salary to be paid during working hours. And the Act stipulates that the salary should not be paid in a place of intoxication or where liquor is being sold. This is very important as an HR manager. Maybe you're an HR manager and you're paying salaries in cash, and then you say, I live near so-and-so, I will take to them their money, and then you go meet them at a liquor store or in a club and you're paying them their salary. That is outrightly wrong, because the Employment Act seeks to protect employees even from misusing the money. And the drafters of the law knew very well that if somebody is paid in a place of intoxication, they will probably intoxicate themselves with all that money if they do not have self-control. So to protect them, they stipulate that you should not pay that salary in a place of intoxication or where liquor is being sold. In case of payment in kind, where it has been agreed. For example, maybe somebody said, my salary is 20,000 and I would like to be given, maybe if you're working in an organization that sells merchandise, maybe a television, and you've agreed that at the end of the month, you'll be, the money that is due to somebody will be paying for a television. You can do that as long as it has been agreed expressly in writing, lest you will have to pay them twice even after giving the television. So when is salary paid? For casual laborers, it can be paid on a daily basis or as agreed by the parties. Most casual laborers these days are paid at the end of the week or at the end of 2 weeks, but you can pay them on a daily basis as well, as long as the same has been agreed. For less than a month period, that is a contract that is less than a month, you can pay them at the end of the stipulated period. And on a normal employment contract, people are paid at the end of every month. Most employees actually extend the time to 5th of the month, but it is considered that it has been paid at the end of the month. And you can also pay salary in case of dismissal or upon dismissal. Upon dismissing an employee, you are expected to pay them their salary. No payment during a period where the employee is serving a sentence of court or is in prison. So if an employee has gone to prison and you have their dues, don't pay them when they are in prison. You have to keep their money until they are out of prison or until they are done serving a sentence of the court. Maybe they have been put on probation or they've been sent to jail. You can wait for them to come out of there, then you can go ahead and pay them. Now, in payment of salary, it is important to itemize the salary so that people can know what you are paying them for. It's very, 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 very important. That is where we see the commonly known as payslip. What is commonly known as a payslip? This is just in line with the Employment Act, which provides for itemization of the salaries. And this itemization should have the basic salary, statutory deductions that we discussed earlier on, overtime pay, if any, payment in lieu of leave, if any, and any other deductions, like we already discussed. We'll not be going back into the deductions because we've had an elaborate explanation of the same, okay? I know this one. Many people want to hear it. Termination and dismissal. This is the thing that always takes HR managers to court, and HR practitioners don't like the court. So I'm going to tell you how to avoid the court in this segment. Okay, it's not only the court, because we have other ways of dispute resolution, but I'm going to show you how to avoid the court. Now, the Employment Act in Part 4 provides for termination and dismissal from employment. First, we will deal with termination. Termination can occur under the following terms. One, when there's an automatic lapse of a term of a contract. Remember when people were asking questions before, if you've given somebody a contract for 1 year and the 1 year comes to an end, that is considered that the contract has been terminated automatically. It's automatic. There's no need for explanation. There's no need for begging. There's no need for nothing. And normally the contract always has a provision whereby if you intend to renew the contract, you write to the employer or the employer writes to you before maybe 3 months before the contract is expired, and they express the intention to renew the contract. Now, in case that intention is not expressed, then it is considered that the contract has automatically terminated. No need for explanation. Many times a contract is over and then the employee keeps coming to work and then they are bothering the HR manager saying they still want to work. If it's not been renewed, it's not been renewed, and that is it. It can also occur when either of the parties cannot go on with the contract. One, maybe somebody is tired. Somebody is tired of working. They can write to and say, I am giving you notice. I am giving you notice that I am tired of working for you, and I'll be resigning from work in a particular month. So be notified. If either party cannot continue with the work, then the contract terminates. It can also occur when somebody is dismissed from work. And we'll be talking about the different aspects under which somebody can be dismissed. Then we also have redundancy. Maybe the position is not needed in the organization anymore. So we have somebody having to leave work because the organization cannot have them anymore, and that position is no longer applicable to the organization. We also have the act of God, which in law is referred to as force majeure. This is when, for example, a private employer dies. There's nothing you can do. For example, if somebody, maybe if it's not a company, if it's a sole proprietorship and the owner of the business dies, there's nothing to do. It's an act of God. Also, it can also occur when the employee dies, or maybe in times of sickness. For example, we saw in 2020, when we had the COVID-19, things changed. Work and employers and employees lost each other. Employees lost jobs, employers lost the businesses. Sometimes the business could close and there's nothing you can do about it. It is done. So we are continuing. In case the term of the contract has not come to an end, but one party wants to terminate, they must give notice as prescribed in the contract of employment or in accordance to a collective bargaining agreement. Now, when you're drafting contracts as HR managers, please remember to always incorporate the termination clause. Okay? Always incorporate a termination clause. When can you terminate? And how many months of notice do you require to give before terminating somebody? Where notice is not given as prescribed, either party has to pay in lieu of notice. If the CBA says you have to give 4 months notice, make sure you give 4 months notice or you'll pay 4 months for free. And there's nothing you can do about that. If the contract prescribes for 2 months notice, make sure you give 2 months notice or you will pay that person for free. 2 months pay for free because you terminated them without notice, okay? But we always see all this craziness coming about when somebody is terminated from work. Everything is always good until the day of termination. That is when you know, oh, you mean it was like this. So make sure you follow the CBA or the contract. Always make sure you don't exclude that from the contract. So what benefits does somebody get when they are terminated from employment? Fairly. We are talking about fair and lawful termination, because in cases where there is unfair termination or unlawful termination, that is where you find many people going to court, or they go to the labor office, or they go to the trade union, and then they complain. So when somebody has been terminated fairly, that is, you have given them notice of termination, say 2 months, and you have gone through the process before termination, you are supposed to pay service pay for every year worked. Okay? If somebody has worked for you for 22 years, that means you will pay them half a month's salary for each year worked. There is normally a confusion between service pay and severance pay. These two are different. Service pay is payable when there is proper termination of an employee from employment. Severance pay is payable when an employee has been declared redundant. When the position no longer exists in a company and you're telling this person, we no longer require a general manager, everything will be handled by the HR, then you have to pay them severance pay. Okay, so how to calculate service pay is for every year worked, somebody gets half the salary. Maybe there has been an increment in salary as the years go by. You can calculate the service pay for each year. It doesn't mean that you are going to use the salary that the person is earning at the time of termination. That is normally the confusion that happens because most employees want to be paid service pay based on the salary that they are earning at the time of termination. This is not the case. You should calculate it on an annual basis based on the salary they were earning in each year, okay? Service pay is not applicable for persons in a pension fund to which the employer is contributing. For example, if you have a private pension fund and you are also contributing, remember when we were saying the 12% is made up of the 6% from the employee and 6% from the employer. So if the employer is contributing 6% to that pension fund, they are not obliged to pay the employee service pay. This is according to the Act, okay? Service pay is also not applicable in case of a gratuity fund or fund established by a CBA. Sometimes we have CBAs that establish a gratuity fund, okay? And the employer is contributing to that fund. They are not expected to pay service pay at the end of the contract. Lastly, service pay is not applicable where the employee is part of the National Social Security Fund, commonly known as the NSSF. If you are contributing to NSSF, that is the 6% of their basic pay, you are not supposed to pay service pay in case of termination. I know that is a very important aspect when it comes to HR managers, because sometimes somebody has been enrolled on NSSF and they've been paid for and they still want to claim service pay. Well, they are not entitled to the service pay in that instance. Now, let's talk about lawful termination. Lawful termination. Well, it's very hard for an employee to accept that they've been lawfully terminated. Very, very hard. And I know as HR practitioners, you've been facing this a lot. Even when you've gone through the process, somebody will come and complain that they've been unlawfully terminated. I don't know if you've had instances where somebody has actually accepted and said, okay, or do they go grumbling and say, I was terminated unfairly, lakini wacha tuachie tu Mungu, you know? So the law specifically provides for aspects that can cause an employer to be terminated lawfully. This is where it has been grouped as a misconduct. A misconduct, and the law stipulates that absenteeism without leave is a misconduct and can subject an employee to termination. If somebody absconds from duty, I see in most CBAs, there's a provision whereby if somebody absconds from duty for 7 consecutive days, then the company or the organization is at liberty to terminate them. And this termination will be lawful, but you have to prove that this person actually absented himself without pay, I mean without leave. They did not have leave and they went away and never communicated. They never said anything to the organization. Then you can terminate them. Intoxication while on duty. Now, for HR managers, I know this has been a subject of discussion. Intoxication while on duty. This is very, very tricky. And the other day I was in a forum where it was being discussed that how much alcohol is intoxication. Kuna kipimo? Is there a measure? Because there are some people who work better when they are intoxicated. Have we faced those kinds of people in our organizations? Have we faced them? This will be a very, very hard aspect to prove when it comes to court. But if somebody is intoxicated to the point of being incapacitated to do their work, then you can terminate them from employment. If you've assigned them a duty and they cannot carry it out because of the intoxication, you can now terminate them from employment. We also have negligence of duty, where somebody outrightly neglects to do their duty, causing the company to or the organization to experience a loss or a degradation in their service. They can be terminated from employment. We also have use of abusive language at work. Many organizations, okay, not many, some organizations have people who use abusive language, and most times they get away from it. But you know, if you're a culprit of that, you can actually be terminated from employment, and your employer would be right, because it is considered that employees should conduct themselves in a manner that is proper for their employer, okay? Refusing to obey lawful instructions. Refusing to obey lawful instructions. At the beginning of your job, or when you're drafting the contract, you always give out the job description. And if the instructions fall within the job description of this employee and they refuse to abide by those instructions, then they can be terminated from employment. Now, what is lawful instructions? Sometimes somebody is told to do something that is unprofessional. For example, if you tell your employee to embezzle funds and they refuse, you cannot terminate them because that is an unlawful act that you're asking them to do, okay? So you cannot terminate somebody for refusing to do an unlawful act. If you send your employee to go and steal, they will not be considered to have done an unlawful act, okay? If somebody has been convicted in a court of law, you can terminate their employment. That is why you see most times employers, when it comes to maybe cases of fraud in companies or stealing, they prefer to first go to the police, report the case, and then the person is tried. After they've been convicted, termination can occur based on the conviction in a court of law. Remember, conviction in a court of law, if somebody has been convicted, they have a right to appeal, and they have a right to exercise the right to appeal before you can terminate them. So, how do you go about issues of termination before you terminate somebody? Before you terminate somebody, please issue warning letters. Issue warnings in writing. These warnings that you're just passing through the corridors and telling somebody, you've been doing this and this and this and this and this and this, and I have warned you. Consider this as a warning. Where will you prove that? How will you prove it if it is verbal? Please Do a warning letter, do a warning in writing, and place it in a file every time an employee does something wrong. How long is a warning letter valid for? For what period of time is a warning letter valid? A warning letter, in some instances, can be valid forever. Okay? In most instances, warning letters are valid for 6 months, 3 months, depending on the policy of the organization. But whatever you do, make sure the warning is in writing. Please abscond from giving verbal warnings because they will not count. You cannot prove it anywhere that you gave this person a warning. Issue a notice to show cause in writing. When somebody has done something wrong, amongst the things that we just discussed in the previous slide, that is the misconduct, please give them a notice to show cause in writing. Let them come and explain themselves why they should not be subjected to disciplinary hearing. Make sure you encourage your workers or your employees to write their responses. Most times, somebody will not write their response, and when you terminate them, they'll now go to court and say, you know what? They did not tell me to give my explanation in writing. And when you're telling them to give an explanation in writing, you give them a time period. I know you're familiar with this because this is your area of practice and expertise, but when you give the notice to show cause, it should be detailed. Many times employees go to court and they say, I was given a notice to show cause, but I was not told what I did. You cannot just write a warning, a notice to show cause saying, oh, you were insubordinate. What do you mean the person was insubordinate? Or you were negligent? What do you mean? What do you mean the person was negligent? You have to show exactly what that person is accused of. For example, if they did not post the books of accounts, or if they did not file the VAT returns by 10th of each month, and then the company was subjected to pay penalties and interest, you have to say, in the month of November 2022, you did not file the tax returns on time, therefore causing the company a loss. This is negligence of duty, and you are therefore asked to show cause why you should not be taken for disciplinary hearing. Your notice to show cause has to be intentional. Don't just write you were negligent. Don't just write you absconded. Don't just write you abused, you are abusive. No. Put the details of the offense that this person, put the details of the misconduct that the employee did, so that at the end of the day, when you are faced by a dispute, you can clearly say, I wrote a warning on this day, it was received by the employee. Make sure the person signs the warning letter. And then I did a notice to show cause, and I told him that he had abused so-and-so on this day, and I asked him to write his response and submit it. He did not write the response, or he wrote the response, and this is the response. Therefore, he is going for disciplinary hearing, because all these steps must be followed, lest you'll be taken to court and be told that you did not terminate the person lawfully. So, after you've given the notice to show cause and this person has explained themselves or failed to explain themselves, you have to have an actual disciplinary hearing. Have an actual disciplinary hearing. And at the hearing, or before the hearing, make sure you invite this person officially. The employee who is considered to have done a misconduct must be invited by letter or in writing, on email, if that is the mode of communication, or by a letter. Inform them that they have been invited for a disciplinary hearing to occur on a specific date at a specific time and for a specific misconduct. Okay? Don't just write and say you are notified that you will be subjected to a disciplinary hearing for negligence. No. Make sure you put the details of the date, the time, the venue, and the offense in details. Otherwise, they will say they did not get a proper hearing, they did not have time to defend themselves. And if possible, and I would recommend that you give them the documents ahead of time, documents that you'll be relying on to do the disciplinary hearing. That's where they will not come for the hearing and say, I was never given these things, and make sure they sign for it. Excuse me, because surprisingly, people change after they've been terminated. They are very nice when they're working with you, and then the moment you terminate them, they change. They will say you never gave them anything, you never gave them anything, and that is it, okay? So if you do not give them these documents and the disciplinary hearing notice, it will not be considered as a lawful termination. In that letter of inviting them, make sure you tell them in the letter that they have a right to appear with an employee of their choice. Do not choose for them a person to come with, okay? They also have a right to come with witnesses to defend themselves. Don't choose which employee this person will come with. And if you do not write them in the letter, they will now come to court and say, I was not informed of my right to come with an employee of my choice. Rather, they chose for me somebody and I found everybody seated and I was all alone and I did not understand the proceedings. So therefore, I was terminated unlawfully, okay? After the disciplinary hearing, you have to issue recommendations of the hearing and the resolutions of the hearing, okay? This is very important because the minutes of this hearing is what you will go with you to court in case of a dispute and in case of a court case. You will be required to take the minutes of the meeting. Now, what many employers face in court is that they have minutes that were never signed by the person who was subjected to disciplinary hearing. In case you have told them of the right to come with somebody and they've come with somebody, let that person also sign the minutes. Prepare the minutes as soon as possible. Before you decide to terminate the person, please make sure you prepare the minutes. Many times employers terminate, they have not done the minutes, and then when the case comes to court, it's when they are running about doing the minutes of the disciplinary hearing for somebody they already terminated. At that point, the employee will say, I was never given the minutes, I cannot confirm the contents of the minutes, so I refuse the minutes. And then your disciplinary hearing will be considered a sham. It will be considered a waste of time. So when you do the disciplinary hearing, make sure you do the minutes, do the recommendations, and have the employee sign the minutes before you dismiss them. Because if you dismiss them, they will refuse to sign the minutes. They will never, in fact, they may not ever step on the premises of your organization. And most times after the dismissal, they will put an order at the gate and say this person should never step in the premises of this employment. And then the person goes to court probably because they have a time period of 3 years to go to court. So maybe they thought they were going to get a job and they didn't get a job. And then 2 years down the line or 1.5 years down the line, they say, let me go to court and claim for unfair termination. And then you'll start looking for people to sign the minutes. Maybe some of them are no longer in employment. What are you going to do? You'll be in court. You actually did a disciplinary hearing, but it will be considered a sham. It will not be considered at all in court. So make sure you follow all those steps when you're doing the disciplinary hearing. Now, inform the employee of the right to appeal in your letter. In your letter of dismissal, please quote, don't be in a rush. Don't be in a rush when doing your letters of dismissal. Be detailed because you have all the details. If you have all the documentation, it will be easy for you. You can go step by step in your letter and say on 20th of January 2021, you were issued with a warning. On 30th of March 2022, you were issued with a show cause and you responded to it by letter dated 10th of April. And on 20th of April, you were given a letter inviting you for disciplinary hearing where you attended at this time in the presence of so and so, together with an employee named so and so, who was chosen by you. You were subjected to a hearing. You signed the minutes. And the hearing, they resolved that you should be terminated. For that reason, you have been terminated from service. You have 14 days to appeal the decision. Okay, if you don't do that, they will come to court and say that you did not inform them of the right to appeal. And all the work you did as an HR organizing all those meetings, I know those meetings are hectic. They have a lot of documentation, they have a lot of politics. You did it all and it will all be flushed down the drain because you did not think it was important to give details in the letter of dismissal. Many times you just get a letter of dismissal that is 3 lines. You have been dismissed. You know, there's no way you will take that letter. It will not stand. It will not stand. And many times HR managers are always complaining that the court is on the side of the employee. No, that is not the case. It's just because the court pays attention to details, okay? And you did not pay attention in your details in your letter. So they will have to tell you that you wasted your time and you did nothing. And there's nothing you can do about it. So that is a snapshot of what you have to consider before terminating somebody from employment. Make sure you do those things because that is your job. That is your job. Your job is to hire and fire. So you have to hire the right way and you have to fire the right way. Otherwise, you will cost your organization a lot of money. You will cost yourself a lot of time, because sometimes you hear an HR manager, when they're going to get a new HR, they're like, what happened to the last one? When that one was around, so many people were fired and the institution has 100 cases pending in court because of this HR manager. And then your reputation as an HR manager will also not be very nice. And I think as professionals, you don't want that for yourself. So make sure you hire correctly by putting details in the contract. Make sure you attach the job description so that at the time when you're telling somebody that they've conducted themselves against their job description, you have evidence for that. Make sure you make known the policies of the organization when it comes to how people are supposed to conduct themselves. And when it comes to time for firing, please fire the right way. Don't be so excited to fire because your organization will pay. Fire the right way, follow the process. Otherwise, you will be saying how you don't like court, how you don't like lawyers, how you don't like judges, how you don't like everybody because you did not do your job right. And you know how to do it. You actually know how to do it. So don't be lazy to do the right thing. So I'll move on swiftly to other areas, other laws that have a bearing on employment in Kenya. And we'll just be going through them briefly because the core employment law is catered for in the Employment Act, which we've discussed in details, okay? So we'll be looking at the Labor Institutions Act, that is in brief. I'm just going to give you the brief of what the Labor Institutions Act provides for. The Labor Institutions Act provides for the National Labor Board, and that is part 2. These are the people that are responsible. They are responsible for telling us how much the bare minimum is, the bare minimum earning of an individual is. Part 4 of the Act, actually Part 3 was establishing the labor court, but that was since repealed. So that is why you do not see it on this slide. Part 4 of the Act provides for the Committee of Injuries. Now, these ones discuss and put into play the work injury benefits and what should be done in case of work injuries. Part 5 appoints the commissioner. It provides for appointment of commissioner for labor and the director of employment and other officers. Well, all the other officers of governments relating to labor are established by Part 4 of the Labor Institutions Act. Part 5, sorry. Part 6 provides for the Wages Council. Wages Council, those are the people who say how much who is earning. I think they're the ones who do the grading of the salary system in government. Part 7 provides for employment agencies. You're wondering, all these people who are doing employment agencies, the ones who are taking people abroad, they are established, they are provided for under Part 7 of the Labor Institutions Act. All these people, maybe you see we have housemaids, and you can come here and fill an application form, and then we'll be giving you trained housemaid, something like that. Those are provided for under that, under Part 7 of the Act. You can go on the Kenya Law website, okay, kenyalaw.org. You'll find a PDF format of the Labor Institutions Act if you're interested in knowing more about it. We also have, in brief, the Labor Relations Act, which in Part 3 establishes it provides for establishment and registration of trade unions and employer organizations. Okay, when we are talking about all these collective bargaining agreements, which are normally brought into place by the trade unions, this is where to find the establishment of trade unions. So you are free to register at trade unions. The bare minimums of registration are provided for under this Act. Part 4 provides for officials and members of trade unions and employer organizations. You know, you may wonder who comes up with these things, chairman and treasurer and blah, blah, blah of a trade union. All these are provided for in the Act. Part 5 provides for property, funds, and accounts of trade unions and employer organizations and federations, okay? Because as we always say, you cannot just come up with something, especially when it has to govern human beings, without an act of parliament. And the Labor Relations Act clearly provides for this. It also provides for trade union dues, agency fees, employer organization fees, because you realize for you to be part of a trade union, you have to pay a fee to the trade union. For you to be part of an employer organization, you have to pay a fee, an annual fee, or a monthly fee. Most times you see at the payslip, they put union dues, okay? So these employees, actually pay dues to be part of the unions. Part 7 recognizes trade unions and collective bargaining agreements, okay? We see when it comes to collective bargaining agreement, there's an aspect of registration, which is also provided for by this Act. If a trade union has not been duly registered in the Employment and Labor Relations Court, then the same cannot be relied on by the employer or the employee in operations of the organization. And these trade unions always change from time. Collective bargaining agreements always change from time to time. You find most of them are normally valid for 2 or 3 years, and then they incorporate a new one. And each CBA has got to be registered in the Employment and Labor Relations Court for it to be valid. The Labor Relations Act also provides for dispute resolution, where it provides for the trade unions to do the dispute resolution. It also provides for dispute resolution in the labor officers. We also have the work injury benefits officers who always try to finish off these problems. And then finally, we have the Employment and Labor Relations Court, which is the top. If you have an issue that has not been resolved by all these other institutions, then you can take it to the Employment and Labor Relations Court. We also have adjudication of disputes in Part 9 of the Act, which basically also provides for alternative dispute resolution, whereby a labor officer or a mediator can be appointed, or a conciliator in this case can be appointed to resolve the issue between an employer and employee without them having to go to court. Part 10, lastly, provides for strikes and lockouts, how they should be organized, and the areas that they should cover when they want to go on strike, okay? So this is our last area of discussion, and we'll be discussing process in dispute resolution when it comes to employment and labor relation disputes. Disputes can be resolved at the trade union level. For example, if somebody is part of a trade union and there's a dispute whereby maybe you want to fire them lawfully, you can approach the trade union and discuss with them, approach them in writing, discuss with them, and tell them the problems that you're facing with your employee. And then they can write to the employee and call the employer and employee to a discussion whereby each side will table their problems, and then the officer of the trade union will try to find a solution to these problems without them going to court, okay? And most times we see actually the trade unions are able to resolve most of these disputes, therefore saving a lot of time and money for both the employer and the employee. We also have the labor office. Now, most times, actually, when people are terminated from work, they do not know how to calculate their dues. What I usually see is that they approach the labor office and tell them, I have been terminated from work, this is my payslip, I've worked for a number of years, and I would like you to help me to calculate my dues so I can share you can share the same with the Mariam, please mute your microphone. I think it's, thank you so much. So they can try to resolve the disputes at the labor office, and then somebody is paid, and that is the end of it. If you go to the Labor Institutes Act, Labor Institutions Act, they will give a comprehensive method through which the labor disputes are resolved at the labor officers level. Well, labor officers and trade unions, they do not like to have legal representation. They do not like to have lawyers in there. They don't want the employer to bring lawyers, neither do they want the employee to bring lawyers, because they believe that lawyers try to make this process be so difficult so they could earn some fees. Okay, is that the position? They prefer to deal with the employer and the employee in person so that the issue can be resolved amicably and everybody can go happy or unhappy or just agree to disagree. So in case you go to the trade union or the labor office and your dispute has not been resolved, you have the last resort. The last resort is the Employment and Labor Relations Court. This court was established to deal with issues of employment disputes that cannot be resolved by trade unions or a labor officer. And people are free to go to either of the three organizations that are in this slide. If somebody likes to go to court, they are free to go to court. You cannot force them to go to the trade union because you want to go to the trade union, okay? Now, I will address another aspect here that is uncommon. Very few employers sue employees. I don't know why the case is like this. Because sometimes the employee is negligent in doing their duties and they've caused you a loss, but as an employer, you just fire them and let them go. Then after 1.5 months or 2, they sue you and say you terminated them unlawfully. Sometimes employees just leave. They don't give notice, they just disappear. Okay? An employer is entitled to claim from the employee who just disappears. Well, some people will say it is being petty. No, it is not being petty, because many a times employers are always blaming the labor relations officers and the courts for being on the side of the employee. But the fact is, the employer lets it be like that, because if there is no example for the employees to learn from, they will not learn. They will always think they have more rights than the employer, which is not the case. The employer has rights as well. They have obligations imposed on the employee. And in case the employee does not satisfy the rights of the employer is also free to go to the trade union and complain and say members of your trade union are supposed to be doing this and that at work, but they are not doing it. Kindly inform them or apprehend them accordingly so that they can do my work better. The employer also has a right to go to the labor office, okay, and complain and say, these employees are not doing this and it is my right as an employer because I pay them a salary, they are supposed to do this. So the employer also has that right. The fact that they do not exercise that right does not mean the right does not exist. Employers also have a right to go to the Employment and Labor Relations Court to seek for compensation from an employee who does not satisfy their rights. Okay? If you do not satisfy your obligations as an HR manager, your employer can claim from you in a court of law. It is not one-sided. The law is never one-sided. It provides for the for the rights of the employer and the rights of the employee. So employers, if you're out there, now you know you've got a right to make a claim against an employee who does not satisfy the obligations that you imposed on them for a contract that they have actually signed. Okay, now that I have finished, telling you your rights as employers, I will go briefly to talk about what the trade union does and when a case can be referred to a trade union. A case can be referred to a trade union in case, I beg your pardon for using case and case. A case can be referred to a trade union if there is an existing collective bargaining agreement. If there is a CBA in place and there is a disagreement, please refer the case to the trade union first before you proceed to any higher authority, and that is the Employment and Labor Relations Court. The agreement must have been registered in the Employment and Labor Relations Court. There is normally a cause list, and these agreements are normally registered in the High Court in Nairobi. In the Employment and Labor Relations Court in Nairobi, there is always a cause list that registers collective bargaining agreements. Now, in case the collective bargaining agreement is not registered, then that collective bargaining agreement cannot be enforceable. It cannot be enforceable. Nobody can claim from it. So make sure if there is a collective bargaining agreement with your employees, make sure it has been registered in the Employment and Labor Relations Court. The trade unions prefer to deal, as I said, with employees directly. As the process they use in determining or solving the dispute is called conciliation. They try to actually, it's like reconciliation, like they put the employer and employee back together and they say, let's solve this issue and let's continue to have a pleasant relationship. If parties disagree with a decision from the trade union, they can go to court. This is provided for under Section 73 of the Labor Relations Act, okay? When can a dispute be referred to a labor officer? A dispute can be referred to a labor officer. All labor disputes are settled through conciliation process as follows. Individual or individual complaints or non-individual complaints. Mary Kay, please switch off your camera. You are distracting the presentation. Thank you, Mary Kay. Thank you for that. The complaint is reported to the area labor officer and registered in the prescribed form. There's a form that they'll give you at the labor office for you to be able to register your complaint. After 7 days, the complaints, I beg your pardon, after 7 days and the complaints have not been settled, the labor officer will call both complainants and the employee for a conciliation meeting. So once you register a complaint at the labor office, they will get in touch with you and try to ask you to solve this. If it's not been solved within 7 days, you are now called by the labor officer and you are called for a reconciliation meeting. If both parties agree on the claims and the complainant is paid and an agreement is signed, then every party goes their way. For example, if the labor officer is able to get a breakthrough and the complainant, the complainant is paid, everybody signs the agreement and everybody goes their way. In case of a disagreement, the conciliator can call another meeting, but in case everything fails, you just have to go to the court, okay? So I'm going to briefly take you to the court process. Well, this slide is talking about how the conciliator is to be appointed, and this is an area that is covered by the Minister for Labor or a Cabinet Secretary for Labor. The appointment of conciliator is required to finalize the conciliation. I beg your pardon. The appointed conciliator is required to finalize the conciliation within 90 days, okay? Let's go to court. Let's go to court briefly. Now, we are briefly talking about the court process. What to expect in case all the other things have failed, or in case somebody prefers just to go to court straight away. This is what is expected. Your company or organization will be served with a demand letter. The demand letter will declare the demands of the complainant or the claimant in this case. Most times it's the employee, because employers, as I said, are not interested in suing former employees. The demand letter will say the person was employed on this day, they were earning this salary, they've been terminated unlawfully, and they were not paid for their leave, they were not paid, given maternity leave, they were not, and all that, and they therefore demand that you give them a specific amount of money within 14 days or blah, blah, blah. If not, they will take you to court. So what do you do in case your organization receives a demand letter? You ask your boss to appoint an advocate to respond to the letter. The advocates always know how to respond to the letters. They know the magic. They know the magic words. That is their job. As an HR manager, unless your company is going to represent itself, which is common when it comes to the trade unions. It's common to have companies represent themselves. So tell your boss or whoever is in charge to appoint an advocate to respond to the letter on behalf of the company. And in case, Judy, please switch off your audio kindly. Judy, kindly switch off your audio. Judy, kindly switch off your audio, please. Or in case somebody is able to mute Judy, kindly mute Judy. Thank you, Judy. Thank you so much for switching off your audio. In a case of a claim, please have proper records. That's why I started by taking you through the hiring process and the firing process. If you do not have proper records, your institution will pay. It will pay for not having proper records. And if you have the records, kindly share them with the advocate as soon as possible, because we have first instances in previous times where documents get lost. When the case comes to court, documents get lost and you're wondering what happened to these documents, you know, but documents get lost and people are left in a state of quagmire. Then lastly, as an HR manager, prepare to attend court as a witness, because you are the one who hired and fired anyway. If you are not the one who fired, sorry for you, you will just now rely on the documents that are on the record or on the file. So make sure the employees have proper records on their file, okay? So these are the documents you will expect when you are in court. You will be served with a statement of claim together with witness statements and any documents if the employee has documents. So what will happen? The advocate will respond to the statement of claim together with the witness statements and documents. Most probably the HR manager will be called as a witness to come and say how they fired the person that they fired. And they will also be required to understand the documents that they will be presenting in court. Parties will be referred to as claimants and respondents. I'm sure you are conversant with this in the Employment and Labor Relations Court. The person who has sued will be referred to be as the claimant, and the person who has been sued will be referred to as the respondent. The claimant may call on former employees, especially to prove that they worked overtime and they were never given uniform. In court, this is what you find. They will call a former employee, maybe who was working with them and then they left employment, or even those ones who are still in employment. They'll come and say, you know, when we were working in the organization, we were never given uniform for 20 years. They like this uniform claim when it comes to court process, because they believe they can get a lot of money from the uniform claim. But anyway, the lawyers know how to tackle that. So make sure you have a lawyer on record. They also always claim for overtime. They say we worked overtime, we worked until midnight during Christmas and blah, 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 blah. And then they call somebody else to come and testify to try and prove their case. So what are the possible outcomes? What are the possible outcomes in a case in court? One outcome is that the case can be dismissed. That is good for the employer, because that way they don't get to pay the cost and pay for everything that the employee is claiming for. The court may award compensation for unfair termination. If you do not have proper records, it doesn't matter how much work you put into the disciplinary hearing, the employee will be paid for unfair termination. I'm sorry, my battery is running low. Let me just put it to charge. Just 1 minute. Oops. So the employer will pay if the records are not properly kept by the HR manager. And in case there are any dues that have not been paid, of course, even if they are not awarded some unfair termination, if the court finds that they were terminated lawfully, then the courts will award any dues that have not been paid. They will be paid. In case they didn't take their leave, they will be paid for the leave. And you might also be asked to pay costs. You may be asked to pay costs in case the person is given an award, or in case there is a dismissal of the case, then you will be asked, the employee will be asked to pay costs. But most times, as I said, employers shy away from following the costs of former employees. And in case either party is not pleased with the outcome of the court, they can always prefer an appeal. For example, if the salary of the person is less than, no, if the claim of the person is less than 20 million, They will start off in the subordinate court, then they can appeal to the High Court, and then from the High Court, you can go to the Court of Appeal. Okay? That is what to expect when you are faced by a court case. Now we are going into the Q&A session. We have 40 minutes for that. I hope I'll be able to answer all the questions that you have asked. Let me look at the chat. I hope I will be able to follow. Let me see the last question. Feel free to post your questions at this moment. I think we had reached the leave. Yeah, we had reached the leave. And Doreen Onyango was saying, replying to how many leave can zero? Oh, no, she was talking about the forfeiting of the leave to zero. Oh, sorry. I have to go step by, oh my gosh. I'm trying to look at the questions now. Okay, wait a minute. Somebody was saying it depends on the company policy. Replying to depends with your company, like those with CBAs in their companies and HR manuals. Okay, I do not follow that. Let me see if there's another question here. Joe is saying our policy is 11 days, but the Act allows 18 months from the end of the leave earning period. This is not clear. Well, the Act is supreme when it comes to provisions of whichever right has been given. Somebody is sending a direct message. I'm trying to go through the questions that were asked earlier, then I can take on your question. What is the maximum age of a child for an employee to be entitled to pre-adoptive leave? Jacqueline, a child is anybody below the age of 18. So even if they are adopting a 17-year-old, they will be entitled to the pre-adoptive leave. So as long as it is below 18, then they are entitled to pre-adoptive leave, okay? Do we have a maximum paternity leave, especially if a male employee has several wives? Joseph Wafula is asking, do we have a maximum paternity leave, especially if a male employee has several wives? That is a very tricky one. I have actually never come across that. Wow. So if somebody has 4 wives and they all give birth in the same year, that could be tricky. Anyone who has an answer to that, because I've never come across somebody who is working and they have more than 1 wife and then they take out leave. I hope I'll find an answer. Let me just go through the others and then I'll get the answer for you. Back to annual leave. 1 leave allowance if it's payable in June and the employee exits in May. Does he qualify? Leave allowance. No, if he exits before his leave, then he does not qualify, because you take 1 month's leave in 12 months period, okay? So if you were supposed to take your leave in August and you exit in June, there is no way you'll be eligible to the leave because it's not consecutive 12 months, okay? Can one request for adoptive leave even if the child is above 5 years or beyond? Yes, as long as the child is below 18. I mean child. According to the Act, child is anybody below 18. Child. So yes, child. Do we have maximum part? In Tanzania, it's up to 4 children only. Oh, only 4 children. The Act in Kenya has not provided for the maximum number of paternity leave one would take. Why would they limit it? What if somebody has 10 children? How come the woman will take 10 leaves? In Kenya, there is no maximum. Reply to leave. You cannot forfeit leave. It's against the law. You will pay for all the accrued leave days once he resigns or gets terminated. It's actually a liability to the company. Yes, that is very, very true. If somebody doesn't take leave, send them on leave by force. Send them. Let me stop sharing the screen. No, we are in the, yeah, we are in the Q&A. Yeah, this is much better. At least I can now see the chat better. It was, the screen was making me not see it properly. Okay, the chats are very many. I'll try to go through all of them. They're very, very, very many. Okay, I was up to here. In Tanzania, 63 days as full pay on sick leave, 63 days half pay thereafter. You can decide to terminate upon, having a doctor's report. Okay, thank you, Simon, for that. Jacqueline says, there are some legislations that says that after 2 months of service, an employee should be entitled to 30 days sick leave with full pay, and thereafter 15 days with half pay. So do we take 30 days sick leave or 7 days leave with full pay? Which one should we follow? No, according to the Employment Act, because this extraction was from the Employment Act, which says 7 days of leave. This is from the Act. But if you have a policy or a contract that has more favorable terms, then of course they will be going with the more favorable terms, okay? If a staff cannot provide proof of marriage, are they still entitled to paternity leave? Well, I don't know why you are saying they will fail to show proof of marriage, because in Kenya, we have different forms of marriage. We have the traditional African marriage. That is where somebody goes and pays the customary, the bride price or the dowry to the family of the woman, and they are considered to be married. Okay, they do not have a document for that. They can choose to register their marriage or not. So what we see these days is people will swear affidavits, and they can marry as many wives as they want. So if you're going to limit marriage to only the ones who have been married civil and in church or in the mosque, then you may not really be fair, because in Kenya we have different forms, and the African marriage, the traditional marriage, you do not have to have a document for that. Though people have opted to actually register the marriages, but it is not a must for the marriage to be registered. Okay. Lillian says, is an employee entitled to leave during probation? No, you are not entitled to leave, because probation period is either 3 months or 6 months. Somebody is entitled to leave after serving you for 12 months, consecutive 12 months. Then in their second year of employment, they are entitled to annual leave. They are not entitled to annual leave before they serve the first 12 months in employment. Simon says, is an employee entitled? Okay. Simon answered that and says, no, Lillian, unless it's an emergency, which is a must for him or her to attend. Anyone experiencing breaking? I hope that was sorted. That was at 9:27. Esther says, what happens if an employee is unwell and refuses to seek medical attention even after the intervention of an employer, but wants to be away from work? An employee doesn't want to go to hospital and they want to be absent from work. Why? Why would they do that? Anyway, in that case, Doreen says they can take unpaid leave or sick off can only be written by a registered medic. Yes, you have to have a letter from the medic for you to give the sick off. So if they do not want to take medication, they don't want to go to hospital, then they can go on unpaid leave. Geoffrey says, so is it illegal to deduct the statutory amount, NHIF, NSSF, from an expatriate's earning? Yes, if that person is an expatriate, remember there's a difference between an expatriate and a non-resident. There's a difference. And an expatriate many times will not have a KRA pin, okay? They just come in, they do something that is for expats. Wachana na hao watu wenye wanakuja, like maybe the people are from Uganda and they are coming here to work for 5 years. Those are not expatriates, okay? If they have a work permit, you have to pay for them in NHIF, but NSSF, no, because NSSF, how will they be enjoying the retirement fund when they retire in the 60s? They'll be in their countries. How will they enjoy it? I think that's the basis of that. NSSF contribution deductions are pegged on the basic salary or on the gross pay. NSSF contributions are pegged on the basic salary. They are not pegged on the allowances. No. The payee is what is pegged on the allowances and everything combined. But NHIF and NSSF are pegged on the basic salary. Martha says, not really. Check NSSF and NHIF Act. I once asked the two bodies and they said NHIF, they pay automatically, but in NSSF, you need to check if they have a similar pension in their own country. It makes sense because NHIF, they could fall sick in Kenya and they need medical attention, but NSSF, they will be going to retire in their countries. So where will they be getting this money, you know? Yeah. Jackie says, if an employer gives nights out at 3,500 per day, should this amount be taxed? Yes, it should be taxed. It is subjected to payee, actually. That is why they put 2,000. That is income tax. Income tax laws are very, very strict, and it's very hard to go around them, okay? Jackie is asking, what is the formula for calculating overtime? Well, the Act provides somebody should work 8 hours. So any hours worked above the 8 hours should be considered as overtime, right? So that is the procedure, the normal working hours, because there are some people who work in shifts. So we cannot say from 8 to is it from 8? From 8 to 4 or from 8 to 5, no. It depends whether the person is working on a shift or not. If an employee is dismissed for involvement in fraud activity of the employer, can employer hold their salaries to compensate themselves? Please explain more about it. No, you cannot hold somebody's salary to compensate yourself. If you want to claim fraudulent loss occasioned by fraudulent activities, you will have to file a civil claim in court and prove it in court, and then after that, you can seek compensation from that employee. You cannot withhold their salary unless they've been proved guilty in a court of law and unless the court has found that indeed you are entitled to compensation from this employee. Neptune, I hope I have answered your question. What happens if the employee resigns immediately without giving a requisite notice? Who do the employers recover such notices if there is no dues to the employee? You can sue them and attach their property. Esther, you can sue them and attach their property. If they have gone and you have no dues, you can sue them and attach their property or their salary at their next point of employment, because this person will probably go to seek employment elsewhere. So if they went without notice, you can sue for the notice, and if the court finds that you are indeed eligible to be paid this notice, you can attach their property, you can attach their vehicles, you can go and attach their salary at their next employment place, okay? I know employers shy away because they don't know where to go. IWG, is it LWG or IWG says, for staff with back problems, aging back issues caused by employer, is an employer obliged to buy an ergonomic chair for them, or what alternatives exist to support the medical issue legally? Well, that's a little bit tricky, because if the injury has been caused during their time of employment, yes, you are obliged to buy them those things because it's something that has been caused when they are in your employment and they are actually doing your work. Do you pay service pay if the employer has been submitting NSSF? No, you do not pay service pay if the employer has been contributing NSSF, National Social Security Fund. You do not. Alice says, is there any law on minimum age for engaging entry-level employees? In case employees are engaged at entry level, have no specific skills and before a year is over, the employer decides that they are too old, e.g. 48 years, and decides to terminate them. What reason would the employer give when terminating, and what is payable to the employee? Well, I feel that that is a discrimination and they could actually sue you and they will recover from you, Alice. Okay? You cannot set a minimum entry and then disqualify them after they've entered the organization. You shouldn't have hired them in the first place, because if you feel that you cannot hire people of 48 years and above, there is no need for you to employ them in the first place, and then you will have no basis of termination. You cannot terminate somebody on the basis of age unless they are retiring. When they are, is it 60 or 65, then they can retire. But you cannot say, oh, now you're 50 and you're too old to work for us. You will be sending them on early retirement and then you will be required to pay them. Okay, Alice, you will pay them. So don't do that. Don't do that. There is no basis at all. It's discrimination. Jacqueline says, is the formula of calculating service pay and severance pay the same? Yes, it is the same. It is the same. It's half a month's salary for every year worked. So it's basically the same. Severance pay is when somebody is being declared redundant, and service pay is when somebody has been working for you and you terminate their service. I'm receiving direct message, but I don't know where to find it. I don't know. Let me see. I don't know. Okay. Esther says, Maureen, your severance pay is payable annual salary and not current salary for the calculated years. Whereas the reference, please, where is the reference, please? No, because you are paying somebody for each year worked. Okay. This I'm saying because of the jurisprudence. Actually, I was supposed to discuss jurisprudence. That is how the courts do it. Because in the Act, there is no formula for calculating the severance pay. But when you go to the court, they will calculate for each year worked. It is not, it's not a mean. They do not just say you are earning 70,000 at the moment and we are declaring you redundant, so we'll calculate half of 70,000 for each year work. Maybe you started by earning 30,000. So they will they will calculate for each year worked. That is why it is each year worked, not the aggregate number of years worked. Okay. Alice says, is an employee who has not completed 1 year of service entitled to service pay or severance pay on termination? No, they are not, because it's not a year. A year is made up of 12 calendar months. And if that person has not served for more than a year, then they are not entitled to that. What are the benefits for permanent employees terminated on account of organizational winding up? Now, if they are winding up, then it's a redundancy. So they will have to get a severance pay. It's like a take-home package for your services being ended before you are ready to end the services. So they will be given a send-home package, what people call I think it's the same like the restructuring of organization. So if it closes, you also have to pay them all their dues, and then you include a severance pay. Can we pay casual wages on a monthly basis? Yes, you can pay casual wages on a monthly basis, but you have to be very, very careful with that. You have to be very, very careful and make sure you incorporate it in the contract as saying that the people are casuals, but they'll be paid at the end of each month, okay? Kindly come again in service pay. Okay, I already cleared the service pay issue. Can you issue a casual contract for a period of 1 year, but have the worker work for specified days, maybe 2 to 3 days, get paid weekly on a daily rate? Esther, that will land you into problems if you do that. Don't issue a casual contract for 1 year. Don't issue a casual contract. Don't do it, because it will land you in deep trouble, and then this person will be considered as your employee. So it is not proper. If an employer invests, if an employer invests accrued gratuity and pays the interest earned to the employee at the end of the contract, is such gratuity interest taxable? Yes, it is very taxable, considering withholding tax has already been applied by the institution where the gratuity was invested. It is very, very taxable. The KRA will tax it. It will tax it as long as it is more than 20,000 per month. Remember, when we were discussing the taxation, we said if it is more than 20,000 per month, it will be taxed. And of course, KRA will come and tax the interest. It will do that. Simon says, Maureen, we have, but there are limits on intoxication. What do we do? What we do is to have a policy and show the limits with measurement tools and fill the form as exhibits, or others do send to hospital for measurement. Okay, Simon says, and he's giving us a very good point here. In case you have a policy of intoxication, please make sure you have a proper policy and make it known to all your employees, okay? Make it known to all your employees and have a measure, an actual measure for which the people will be subjected, okay? When implementing a new salary structure, how would an employer implement it so as to ensure old experienced employees who have probably stagnated in the old salary structure upon getting to the end of the old structure are not disadvantaged and thus their seniority? Okay, Alice, this aspect is not catered for under the law. As long as you're paying somebody above the bare minimum, then you can restructure the employment however you want, okay? Simeon has also responded to you. Okay, I'm going faster with the questions because I see we have 12 minutes left. Must an employer terminating a contract give a reason for termination, considering the clause in the contract that either party can terminate by giving 1 or 3 months notice or paying in lieu of? Yes, you must give a reason for termination. You must give a reason for termination. You cannot just terminate. You can just say the contract is coming to an end, or we are not happy with the way you're doing things, and then you terminate. You have to give the notice and the reason why. In case an employer pays secondary income to an employee by virtue of the fact that the employee is on another payroll, how should payee be calculated? Now, both salaries will have to be taxed, Wilfred, because KRA just wants the money. They are interested in the money. So yeah, all salaries will be taxed according to the measure provided by KRA. Mariam says, during disciplinary hearing, can they bring along a lawyer? Well, if they choose to bring a lawyer, they can bring a lawyer, because some of them want to bring lawyers, but in the system, it's not proper for a lawyer to be present at the disciplinary hearing, unless the company will also bring its lawyer. Because I know a disciplinary hearing process is one that is established by the company to manage the discipline of its own company, okay? Must an employer Yeah, Simon says the reason must be explained in the letter. The law policy broken must be highlighted. Yes, so it's important to explain. Somebody else is saying in the disciplinary hearing, no, the employee will be represented by a union person or a fellow employee of her choice. Okay. Ali says, if a fellow employee is chosen to accompany me to a disciplinary hearing is a lawyer, is that allowable? Okay, they will not basically be representing you, they will just be accompanying you. And is this accompanying employee required to talk or offer a defense on behalf? They can be a witness, but they cannot offer a defense, okay? If management gives a directive to terminate employee, which is in the view of the HR is unlawful, what resource do you have as an HR manager to challenge this directive? You have the obligation as an HR manager to inform your bosses that what they want to do is not proper, and you can decline to terminate, because at the end of the day, if you terminate and they go to court and they win, then you will be blamed, okay? Yes, as Simon says, the job of an HR is to advise. Okay, thank you for that, Simon. There are so many replies to that. Okay, Lilian says, does an employee have to notify an employer of their desire for non-renewal of a fixed-term contract, or can the employee just walk away upon expiry? You can just walk away. You can just walk away. There is no need for that. Good morning. I have learned a lot in this session. Thank you. I have a question. Can someone resign, serve notice, and sue for constructive dismissal, or for constructive one does not serve my? Yes, you can. You can serve a notice for constructive dismissal, and you can sue. Of course, you can sue for constructive dismissal, because if you've been what is it called? You have been frustrated at work. Okay. Jen says paternity is provided 10 working days. And Jen, I would like to respond. The Act provides for 14 days per year, okay? Mary Kay says paternity leave is 14 days per year. I believe this is per year. So if you have several wives, you plan, otherwise you go just once. This is my understanding. Okay, yes, Mary, you have a point. When shall the term be fixed for service? When shall the terms be fixed for service? I don't get your question. Danny, I do not get your question. I don't know. I do not get your question, but always put the contract terms in the contract. Not employees normally register their next of kin during onboarding. That's the recognized. Wait. Oh, Judy says that the employees register next of kin, so those should be recognized during paternity. Not really, because somebody can have their mother as a next of kin. So it is not a must for them to be the ones to be recognized. Human and Resource Policy and Procedure Manual states how many spouses will be recognized under one employee. So if one has more spouses, that will not apply for him to take paternity leave for the other spouses. Okay, thank you so much, Julia, for that. Thank you so much. And thank you for the reactions. Please elaborate on prorated annual leave, 1.5 days of every complete month. Okay, these ones, they are this one actually I normally see it people claiming they do not take the prorated leave. I think this is a way to ensure that somebody rests, and if they do not take these days off, they would now be required to be paid for the prorated leave. Is miscarriage, stillbirth leave, and if so, how many? Yes, you can still have a leave at least a month. I think this is on a humanitarian basis. It's on a humanitarian, because especially for stillbirth, they still give birth, so they can have 3 weeks, 3 months to recover. Okay. How do you calculate evaluation of basic salary for staff consolidated pay, where some payments deduction are based on basic pay? Yeah, it's very hard to do the consolidated pay. That is why it's important to have an itemized pay slip. Please clarify on leave. Since leave is earned per month, e.g. 2 days per month, then if I exit at 9 months of contract, shouldn't I be paid for 18 years? The question is not clear. Is it legal to withdraw the last months of salary for an employee who is retiring or contracts ending until they clear, so that to take care of liabilities owing? Well, it's not right to withhold the salary. It's better you make sure they clear everything and then you pay them at once, not necessarily to withhold, because you'll have to go to court to prove your liability unless it has been agreed upon by both parties. Okay. Yes, if you're offering housing for the employee, is it right to capture the same 15% of basic pay in their payslip and subject the same to payee? Yes, payee they require that you do exactly that. You're required to capture it. Okay. Let's see. I'm trying to summarize the questions. We have 18 minutes to go. In case I do not answer your question, there's always another program that will be organized and we can have the question in that program. Okay. Can an employee resign or serve notice then sue? Yes, we already answered that, Joel. And Joel, we already answered that. I see a post from the SEHRP reminding people of the login. Okay, this was at 11. If someone is employed as a casual and he or she works for 6 months and you give them 4 rest days every month, does this justify converting their employment for permanent? Yes, Jacqueline, the employment will be converted to a normal employment, and then they will be entitled to all the rights that we discussed above. In this case, you have a trainer or an instrumentalist who gives notice service for 2 hours and 8 hours on Sunday. Should he get a yearly service contract to be paid end of the month? Well, Lucy, if you're drafting your contract, you really have to be intentional in your contract and be specific. If this person is a casual, and I would recommend that you give a contract of 3 months. You can always, don't be lazy, because that's how people are got on the wrong side of the law. Don't be lazy to give timely contracts, because at the end of the 3 months, you can always renew their contract. Otherwise, you'll be caught on the wrong side. If someone is denied a promotion under unclear circumstances, having fully met the requirements for promotion and passed an interview, upon appeal, can they be paid as at the time they ought to have been promoted? Backdated promotion. The other day, I was actually surprised. There was a backdated promotion in the government. There's some area, I will not mention the area, but I saw people saying they've been, their promotion has been backdated and they were paid. They were paid a backdated salary as from September last year. I don't know how practical that is, because if they now appeal, the promotion has occurred after the appeal. The law cannot act retrospectively. So if they appeal and then get the promotion starts on the day after they have been promoted. Okay. Catherine is asking, where do we get CBAs that are registered? If you go to the high courts to the Employment and Labor Relations Registry in Nairobi, you will be able to get the registered CBAs, because every time they register the CBA, a copy is placed on the file, and the same can be accessed from the High Court Registry. Okay. Somebody is asking, how long can someone act? I don't really get your question. I don't get it. So we have 4 minutes to go, and I can see ACHRP is on the panel. If we could have a word from you before we close, because we have only 4 minutes, and I have answered all the questions that are on the chat. But otherwise, I would like to thank you all for your attention. Thank you so much for your attention.
Hi.
Yes, good morning.
Very well. Thank you very much, Maureen, for taking us through this particular course on labor legislation. To our participants, thank you for turning out in large numbers to participate in and ask these beautiful questions that we usually do in our WhatsApp groups. Today we brought on board an advocate of the High Court so that she'll participate with us as we ask her those HR questions that we face on a daily basis. Maureen, I don't know whether you knew that HR is a calling. It's like becoming John the Baptist. So we usually face those legal issues, and sometimes we may find ourselves between a rock and a hard place, especially where we have to advise our employers that we need now to bring in an advocate for purposes of litigation or defending the company for errors of omission and errors of commission. So we are going to have another session with you soonest. And for our participants, I would want you to look forward for our particular program. This will be on certified employee relations professional. And Maureen, together with others, will take us through that particular program. That will be in mid-June in Diani. I look forward to seeing you there. You can start preparing as early as now for purposes of meeting us or meeting our trainers. And Maureen, you promised there will be a judge of the Labor and Employment Court.
A judge might be hard to get. Maybe a magistrate that can come in, the one who handles employment and labor relations, because these days it's handled even at the magistrate level. So yes, because the judges are very hard to come along.
Later on, we are going to bring in the Chief Justice at some point and see how we'll get there. So, ladies and gentlemen, before I end this session, if you'll be interested in acquiring the certificate for today's training, I've shared the process. I have a cat here which is making some nice noises. Now, the process is there. You log into our website, achlp.org. You can write that, achlp.org. These days we have automated the process, and we've made the process of registration for courses very easy. You log in, the landing page you get will be my courses. We've given you all the courses that we have. You're able to access the notes, you're able to access the videos there for free actually. But now when you want to access the certificate for that particular course, there is the pay button. Click pay, and the course will, the system is going to approve your registration. Website is achlp.org. You enter your email, the password at all times. Even if today you've not created your account on our website, the password will always be HR2021. maybe I could show you something. So when you go to our website, it will get you to our homepage. It will get you to our homepage, and you look at the top there. What I've typed is achlp.org. And by the way, last year we were #1 on those people who've been able to use technology highly, to leverage on technology to bring our services closer to the people. So you'll put in your email. My email, for example, in this case is Den Gavito. No one can be able to log into to tamper with your courses. I can't even delete any course that I have. So I log into my account. I've put in the password there, HR 2021 for all of us. Don't know. Just a moment. Then I don't know, something is giving the system some, it's not moving, but don't worry about that. We will, it is an easy process. You get in there. If you have a problem, I've shared my number with you, 0722 300 245. You can WhatsApp, say hi, I was in class. If you are not in our WhatsApp groups, again, text, I will add you to one of our, we have 30 groups that are most of them are full, but we'll create a space for you so that you are able to maybe continue with the discussion and for purposes of future discussions. Our next training, next week, that is on Saturday, 13th May, will be on HR metrics and measurement. Again, I've set aside or I've made available another very a very inspirational trainer. His name is Tom Ntere. You will find that training, is practical training on HR metrics, to be something to look forward to. You're all welcome. Admolin, you're also welcome, so that you also see the other end of HR metrics, what to measure, why measure, and why we say that if something cannot be measured, then it is not worth doing. Thank you very much. I want to end this session, and I wish you God's blessings. Have a beautiful Saturday, and you're welcome for lunch. Karibu.
Asante.
Thank you, Maureen. Thank you, everyone.